Hello guys, welcome back to our channel Legal Nexus. In this video, we'll explore the fascinating field of normative jurisprudence, a branch of legal philosophy that goes beyond describing what the law is to examining what the law ought to be. It deals with moral, ethical, and social principles that should guide the creation, interpretation, and application of law. By addressing questions of justice, fairness, and rights, normative jurisprudence bridges the gap between law and morality, aimed to shape a legal system that reflects the values of a just society. Let's dive into normative jurisprudence. Normative jurisprudence is a branch of jurisprudence that deals with the normative aspects of law, focusing on the moral and ethical dimensions that underpin legal systems. It seeks to understand the nature of law in relation to moral values and principles, examining how law ought to be, rather than merely describing what law is. Normative jurisprudence is concerned with the evolution of law based on moral and ethical standards. It involves assessing the legitimacy, justice, and morality of legal norms and institutions. The scope of normative jurisprudence encompasses a wide range of issues, including the nature of legal obligation, the relationship between law and morality, and the role of law is promoting social justice. Historical development of normative jurisprudence. The historical development of normative jurisprudence is deeply rooted in the philosophical debates surrounding the nature of law and its relationship with morality. The discussion can be traced back to ancient philosophers such as Plato and Aristotle, who explore the connection between law and justice. The key concepts of normative jurisprudence include the nature of legal obligation, the relationship between law and morality, the role of law in promoting social justice, the concept of justice and its various interpretations. Theories within normative jurisprudence can be broadly categorized into several standards, include natural law theory, legal positivism, and critical legal studies. Hans Kelsen, he is the founder of this theory. Kelsen was born at Prague in Australia in 1881 and was a professor of law at Vienna University. He was also the judge of Supreme Constitutional Court of Australia for 10 years during 1920 to 1930. Thereafter, he shifted to England. He came to United States and worked as professor of law in several American universities and authored many books. He was emeritus professor of political science in California University when expounded his pure theory of law, which is considered to be Kelsen's unique contribution to legal theory. Kelsen's pure theory of law is akin to that of Austin's theory of law. Although Kelsen, when he began to develop his theory, was quite unaware of Austin's work, he nevertheless recognized the essential identity of his own objectives with Austin's, namely to base a theory of law on a positive legal order or on a comparison of the contents of several legal orders and thus by confining jurisprudence to a structural analysis of positive law to separate legal science from philosophy of justice and sociology of law. He wished to free the law from the metaphysical mist with which it has been covered all times by the speculations on justice or by the doctrine of just naturally. In this sense, Kelsen's theory is called the pure theory of law. Pure theory of law. A theory of law should be pure, that is, free of extra legal influences of any type. As a result, Hans Kelsen believed in and promoted a theory that was free from any extra legal aspects such as sociology, philosophy, ideology, psychology, politics, ethics, so on. Kelsen quickly detected the law belongs to human science rather than the scientific science. According to Kelsen, the pure theory of law is so named because it exclusively describes the law and strives to exclude anything that isn't precisely legal from the object of this description. This goal is to free legal science of alien components. On this basis, two elements, Kelsen stated that his hypothesis is pure. For example, it distinguishes between law and fact. Second, it distinguishes between moral and law. Kelsen views go counter to the notion of precedence, which state that legal idea merged as a result of cases being decided. Kelsen's pure legal theory does not represent the reality of real world legal systems. Kelsen's pure theory of law aimed to purge law of all impure or foreign aspects, leaving material that is purely legal. From a legal standpoint, the law is a standard, not an actuality. Kelsen's criticism of natural law. Kelsen's explanation of normative is intertwined with his criticism of natural law theories, of which he feels he is the only viable alternative. According to Kelsen, there is no explicit idea of legal validity in natural law. Moral validity is the only idea of validity. Natural law theories, according to Kelsen, are conceptually confused. One is secular while the other is religious. Natural law is logically binding and self-evident according to secular conception. According to religious view, these are divine instructions that must be obeyed by humans. The fundamental principle of the secular theory is that nature must be respected, whereas the fundamental principle of the religious theory is that God must be respected. Another critic level towards natural law by Kelsen is that its theories are unscientific and hence cannot be objectively proven. Kelsen's ideas aim to isolate what makes a law legal without having considered morality. Kelsen established his theory by distinguishing between perspective and descriptive elements of positive law. Kelsen dives deep into this idea in search of a perspective component, unlike Bentham and Austin, who tried to define how a legal system functions. Essentials of Kelsen's system. The essential foundation of Kelsen's system may be enumerated as follows. The objective of theory of law as of any science is reduced chaos and multiplicity to unity. Legal theory is a science and not violation. It is knowledge of what the law is and not of what it ought to be. Law is normative and not a natural science. Legal theory is a theory of norms and is not concerned with the effectiveness of legal norms. Features of Kelsen's theory. The theory of law must be ideal with the law as it is and not with the law as it ought to be. It must concern with existing law. The theory of law is different from the law itself. Law is a mass of heterogeneous rules. The functions of the theory is distinguished between the different type of law. A theory of law must be pure. It must be free from all ambiguities. A theory must explain all the aspects of law without reference with other subjects like sociology, political science, economics, history, etc. because they are subject to variation from one place to another and from one time to another. The pure theory, which would have the ingredient of only one discipline. For example, law. Law is a norm which is prescription norm, the function of which is to prescribe. Finally, there comes the highest norm to which all inferior norms derive their value, which is ground norm. Kelsen's approach is much wider than that of Austin's, as Kelsen include policy, rule, doctrine, and standard in addition to the commands with the purview of the norm. Normative jurisprudence play a vital role in guiding the development and application of law by focusing on what the law ought to be rather than merely describing what it is. It provides moral, ethical, and physiological foundation that shape legal principles, ensuring that the law promotes justice, fairness, and social welfare. By examining the values behind legal rules, normative jurisprudence bridges the gap between law and morality, making it an essential tool for building a just legal system. Thank you for watching this video. If you like this video, please like, share and subscribe for more legal insights.